Hello guys, welcome back to Wiser Pinoy TV. This is again James and Violon, and we will be continuing our discussion on Article 13 of the Revised Penal Code, which is the mitigating circumstances. Now, we have already discussed Article 2 through Article 12 of the Revised Penal Code, and now let's continue our discussion on the Article 13 of the Book 1 of the Revised Penal Code. So Article 13 is all about the mitigating circumstances. So when we talk about mitigating circumstances, according to the Revised Penal Code, the following are the mitigating circumstances. Let's enumerate them one by one. First, those mentioned in the preceding chapter when all the requisites necessary to justify the act or to exempt from criminal liability in the respective cases are not attendant. Second, that the offender is under 18 years of age or over 70 years. In the case of the minor, he shall be proceeded against in accordance with the provisions of Article 80 of the Revised Penal Code. Third, that the offender had no intention to commit so grave a wrong as that committed. Fourth, that sufficient provocation or threat on the part of the offended party immediately preceded the act. Fifth, that the act was committed in the immediate vindication of a grave offense to the one committing the felony or delito, his spouse, ascendants, descendants, legitimate, natural, or adopted brothers or sisters or relatives by affinity within the same degrees. 6. That of having acted upon an impulse so powerful as naturally to have produced passion or obfuscation. 7th, that the offender had voluntarily surrendered himself to a person in authority or his agents, or that he had voluntarily confessed his guilt before the court prior to the presentation of the evidence for the prosecution. 8. That the offender is a deaf and dumb, blind, or otherwise suffering some physical defect which thus restricts his means of action, defense, or communication with his fellow beings. 9th, such illness of the offender as would diminish the exercise of the willpower of the offender without, however, depriving him of consciousness of his acts. 10. Finally, any other circumstance of a similar nature and analogous to those above mentioned. Now, we have to remember that when we talk about the mitigating circumstances, these are circumstances that lower the penalty of a person committing a felony or a crime. We need to remember that when we talk about mitigating circumstances, this does not entirely free the actor from criminal liability, but serve only to reduce the penalty. So we have to be very clear on that. Now, kanina sabi ko yung justifying and exempting circumstances need not be alleged in the information. This one also. You do not need to allege this in the information. Because when the accused killed the victim, he did it out of passion and obfuscation. Walang ganon. So, swerte naman ng accused pag kayo naging fiscal or wag niyong gagawin yan kasi baka itapon nila yung kayo sa malayong lugar o di kaya baka ang ipapahawak na kaso sa inyo is traffic violation. Wag naman. Kailangan pag yung fiscal, for example, yung fiscal, ang hinahawakan na crime should be heinous crimes like rape, robbery, with homicide, murder, and ganyan para may challenge on the part of the prosecution or fiscal. Now let's categorize mitigating circumstances. There are three kinds of mitigating circumstances. One is ordinary, reduce the penalty by minimum term. Second is the privileged, lower the penalty by degree. And of course, the relevant in the intermediate sentence law. Okay, so let's differentiate now ordinary mitigating circumstance versus privileged mitigating circumstance. Ano bang kaibahan ng ordinary mitigating circumstance and ng privileged mitigating circumstance? Now, the ordinary mitigating circumstances apply to all felonies. Take note of that. it may be considered in all felonies. So dapat familiar kayo dito because they serve to reduce the penalty by period. I hope you are already aware of the period. This can be offset by the presence of an ordinary aggravating circumstance. Now, balik tayo sa period. When we talk about period, this refers to maximum, medium, and minimum. Okay? Now, when we talk about degree, from reclusion perpetua down to reclusion temporal, so that is what we call mitigating by degree. Okay. Now, the privileged mitigating circumstance will have the effect of reducing the penalty by degree or degrees. Yun yung sinabi ko kanina. So, this cannot be offset by the presence of an ordinary aggravating circumstances. Take note of that. So, the following are the privileged mitigating circumstances. So, kailangan nyo maging clear. What are these privileged mitigating circumstances na pinagsasabi natin? One is minority. Now, minority is a privileged mitigating circumstance. Okay? Second, incomplete justifying or incomplete exempting circumstances under Article 11 and 12. Okay? And third, when there are more than one mitigating circumstance and there is no aggravating circumstance. Ito yun yung application ng tinatawag nating intermediate sentence law or ISLAW. Okay. Take note that this is not applicable to special penal laws. Okay? Mitigating and aggravating circumstances are not applied to special penal laws because the penalties is in special laws cannot be divided into 3 periods. Okay? Take note of that. In the revised penal code kasi, meron tayong tinatawag na divisible and indivisible penalties. So, pag sinabi nating indivisible penalty, nagre-refer ito sa reclusion perpetua to death. So, since wala naman tayong death ngayon kasi hindi naman suspended man ito, so, meron tayong reclusion perpetua being the highest penalty available in our penal system. Okay? So, wala namang death penalty ngayon, sabi ko. So, it's not applicable in the special penal laws. So, as what I have learned also in my study of law, there is an exemption here. It is when the special penal law specifically provides to refer to the revised penal code for the attending circumstances. Kasi may mga special penal laws also which also specifically provides to refer the penalties to the revised penal code. Now, if that would be the case, now applicable dito yung tinatawag nating divisibility ng penalty. Okay? Now, let's proceed to Article 13, Paragraph 1. The incomplete justifying or exempting circumstance says, so this is considered a privileged mitigating circumstance provided majority of the elements required to justify or exempt are present. Now, for the justifying circumstances of self-defense, defense of relative, and defense of stranger, the element of unlawful aggression should always be present because based on our previous discussion, if itong element na unlawful aggression is absent, in attendant ito sa isang situation, then there is no way for us to consider it as an incomplete justifying or exempting circumstance. Ito is inevitable element ito. So, bahala na yung dalawa kung wala yung dalawa as long as itong element na to dito ito. Okay? So, yung unlawful aggression, it's either sasamahan yan siya nung dalawa pa na elements or requisites ng justifying circumstances, yung tinatawag nating URL, So, ito yung tinatawag nating pag isa ang wala doon sa dalawa, take that always dapat dito yung unlawful aggression. So, if majority or 2 out of 3 elements or requisites are present, then this is what we call the incomplete justifying circumstance. Okay. So, let's proceed to Article 13, Paragraph 2, the minority. So, when we talk about the minority, that covers that covers minors above 15 years but below 18 years of age. So, that's 16 to 17 years old who acted with discernment. So, if the person or if the minor acted with discernment, so ito yung situation wherein pwede siyang mapunish. Kasi may discernment. What our law provides is if walang discernment, totally exempted, diba? Okay. So, if that would be the case, there is a privilege. Now, I would just like to clarify this para hindi kayo malito, ha. Now, if itong minority which covers the minors from above 15 years old but below 18 years of age, 16 to 17 years old, who acted with discernment, this is not an exempting circumstance, but rather this becomes a privileged mitigating circumstance. Why? Because the law provides that a minor can only be exempted with criminal liability if he acted without or with no discernment. Okay? Take note of that. Kasi pag may discernment, it is not considered as exempted. Kung hindi, mitigating lang siya. Privileged mitigating circumstance. Take note of that. Now, the basis for the mitigation or the diminution of intelligence is between 15 to 18 with discernment. So that's privileged mitigating circumstance reduced by 1 degree. Okay, let's say for example, na-commit ng 16 years old with discernment, alam na yung ginagawa niya is homicide. So that is reclusion temporal, punishment by reclusion temporal. And since minority is considered as a mitigating circumstance, particularly a privileged mitigating circumstance, and the law specifically provides that itong circumstance na ito bababa ng 1 degree. Okay, so from reclusion temporal, the penalty will become prison mayor. So, yun yung application natin yan. But take note, without discernment, when we talk about discernment without knowledge or without consciousness of what he is doing, then totally exempting yan. Okay? What we are talking in the mitigating circumstance is only a minor committing a particular felony with knowledge or discernment. Okay? Now, let's proceed to article. Punta tayo sa pinaka-meat talaga, lalaktawan natin yung mga hindi masyadong cover ng board exam. Now, let's proceed to article 13, paragraph 7, the voluntary surrender or the voluntary confession of guilt. So, take note of this. This is very technical kasi may mga circumstances wherein nagsosurrender ka, you thought that that is a mitigating circumstance, pero technically hindi na pala siya saklaw ng ating batas. Take note, hindi lahat ng surrender or voluntary surrender are recognized under our law to be qualified as a mitigating circumstance because meron tayong tinatawag dyan na mga conditions. Let's say for example, when you voluntarily surrender or confess your guilt, it should be spontaneous. No? Spontaneous by saying that there must be an acknowledgement of your guilt, or because he or she wishes to save them the trouble and expense necessarily incurred in his search and capture. So, bakit, ano bang rationale nito? Bakit binababa ng korte o ng batas natin yung penalty once you surrender voluntarily or you voluntarily confess your guilt? Because we are helping the state, to save expenses or resources necessarily para sa pag-search and capture mo. So, what are the elements of voluntary surrender? Ito yung dapat important, One, the accused has not been actually arrested or apprehended. Meaning, when we talk about voluntary surrender, hindi ka pa na-capture or hindi ka pa na-apprehend. When we talk apprehend, hindi ka pa na-arrest. Okay? So, ang mangyayari nito is hindi hindi mo hinintay na dakpin ka or hulihin ka ng mga pulis, you automatically surrender sa pinakamalapit na presinto. Okay? And second, he surrendered himself to the person in authority. So, remember that under our law also, it has been enumerated who are the person in authority. So, ang pinakamadali nito na example natin is yung pulis mismo sa pinakamalapit na presinto. And the third element of voluntary surrender is his surrender must be spontaneous. So, when we say spontaneous, pagka-commit mo ng act or pagka-commit mo ng crime, automatically, without a doubt, pumunta ka agad-agad sa police station, pinakamalapit na police station to surrender yourself. Okay. Okay, let's proceed now to how about voluntary confession of guilt? What are the elements or requisites? Now, iba ang voluntary surrender sa voluntarily confession of guilt. Okay? Kasi yung voluntary surrender, that is prior to the apprehension. Itong voluntary confession of guilt, this is prior to the proceeding in the court. Now, the first requisite for voluntary confession of guilt is that the offender spontaneously confessed his guilt. Okay? That the confession of guilt was made in an open court, that is before the competent court that is to try the case, and that the confession of guilt was made prior to the presentation of evidence of the prosecution. So that is the most appropriate phrase, no? Now, this is the perfect timing for you to voluntarily confess your guilt prior to the presentation of evidence for the prosecution, because once the prosecution has already presented other evidence before the court, then you are no longer allowed, or your confession of guilt is no longer considered as voluntary confession of guilt. It's no longer a mitigating circumstance. When is the perfect timing? During arraignment. Now, diba, yung arraignment is you will be asked whether you plead guilty or not. Now, when you say you did not plead guilty, so meaning the trial will proceed until it will be finished. But if you will say, I plead guilty, that is an example of a voluntary confession of guilt. Okay. Now, let's proceed to the aggravating circumstances, Article 14. Now, the Article 14, aggravating, if Article 13 is about mitigating circumstance, kung ano ang mga circumstances na nagpapababa ng penalty, ito namang aggravating circumstances, ito yung kabaliktaran because nagpapataas ito ng penalty. So, the following are aggravating circumstances under Revised Penal Code Article 14 of it. 1. That advantage be taken by the offender of his public position. Second, that the crime be committed in contempt or of with insult to the public authorities. Third, that the act be committed with insult or in disregard of the respect due to offended party on account of his rank, age, or sex, or that it be committed in dwelling of the offended party if the latter has not given provocation. Fourth, that the act be committed with abuse of confidence or obvious ungratefulness. Fifth, that the crime be committed in the palace of the chief executive, referring to the president, or in his presence, or where public authorities are engaged in the discharge of their duties, or in the place dedicated to religious worship. Sixth, that the crime be committed in the nighttime or in the uninhabited place or by a band, whenever such circumstances may facilitate the commission of the offense. Whenever more than 3 armed malefactors shall have acted together in the commission of an offense, it shall be deemed to have been committed by a band. So that is the legal definition of what is a band. Okay, more than 3 armed malefactors. So minimum of 4, no, malefactors or yung mga culprits. Seventh, that crime be committed on the occasion of a conflagration, shipwreck, earthquake, epidemic, or other calamity or misfortune. That the crime be committed with the aid of armed men or persons who ensure or afford impunity. Ninth, that the accused is a recidivist. So when we say about recidivist, or when we talk about recidivist, it is one who at the time of his trial for one crime shall have been previously convicted by final judgment of another crime embraced in the same title of the revised penal code. Tenth, that the offender has been previously punished for an offense to which the law attaches an equal or greater penalty, or for two or more crimes to which attaches a lighter penalty. That the crime be committed in consideration of a price, reward, or promise. That's the 11th. The 12th, that the crime be committed by means of inundation, fire, poison, explosion, stranding of a vessel or intentional damage thereto, derailment of locomotive, or by use of any other artifice involving great waste and ruin. 13th, that the act be committed with evident premeditation. 14th, that craft, fraud, or disguise be employed. 15th, that the advantage be taken of superior strength or means be employed to weaken the defense. And 16th, that the act be committed with treachery or alevosía. Okay? There is treachery, so let me define what is treachery or alevosía. There is treachery when the offender commits any of the crimes against the person, employing means, methods, or forms in the execution thereof, which tend directly, especially to ensure its execution, without risk to himself arising from the defense which the offended party might make. 17th, that means be employed or circumstances brought about which add ignominy to the natural effects of the act. 18th, that the crime be committed after unlawful entry. So when there is an unlawful entry, there is an unlawful entry when an entrance is effected by a way not intended for the purpose. Okay, so hindi talaga siya daanan, like window, doon dumaan yung tao, pumasok sa bahay. So that's an example of unlawful entry. That a means to the commission of a crime, a wall, roof, floor, door, or window be broken. Okay, binasag, may sinira. So, that the crime be committed with the aid of persons under 15 years of age or by means of motor vehicles, airships, or other similar means. And 21, that the wrong done in the commission of the crime be deliberately augmented by causing other wrong not necessary for its commission. So again, what are aggravating circumstances? This may increase penalty or changes the nature of the crime. Okay, so among the jima'a, the justifying, exempting, mitigating, aggravating, and alternating, this must be alleged in the information. Ito yung ilalagay niya sa information. Now, if exempting, justifying, and mitigating, they are not required to be alleged in the information, ito namang aggravating, this must be alleged in the information. Okay, let's say for example, how would you allege that? That on or about May 1, 2019, the accused did and there willfully, unlawfully, and feloniously commenced the commission of a crime of, with intent to kill, with the use of motorcycle, by means of reward or prize. So all of this, you must allege this aggravating circumstances in order for the court to know what are the circumstances that may change the nature of the crime. So the revised rules of criminal procedure now provides that aggravating circumstances must be alleged in the information to be validly appreciated by the court. That's based on People v. Aguilar, case 540 SCRA 509. So, the law and jurisprudence require that aggravating circumstances should be expressly and specifically alleged in the complaint or information. Otherwise, the same will not be considered by the court even if proved during the trial. No? So, meaning, if hindi mo ma-allege yung aggravating circumstances, so, ang mangyayari niyan, the court will only judge the case based on its original form or natural form. No? Wala siyang mga augmenting factors or aggravating circumstances. Now, take note that the aggravating circumstances must be established with proof beyond reasonable doubt, since we're dealing with criminal case. And so the quantum of evidence required there is beyond reasonable proof, beyond reasonable doubt, and any doubt as to their existence must be resolved in favor of the accused. That's according to People versus Cayago. Okay, so let's touch criminal procedure. Now, the rules provide in Rule 110 of the Rules of Court, rather, Section 8, designation of the offense. So, the Rules of Court provides that the complaint or information shall state the designation of the offense given by the statute, aver the acts or omissions constituting the offense, and specify its qualifying and aggravating circumstances. So, if there is no designation of the offense, reference shall be made to the section or subsection of the statute punishing it. Now, in Section 9 of Rule 110 of the Rules of Court, the cause of the accusation, the acts or omissions complained of as constituting offense, and the qualifying and aggravating circumstances must be stated in ordinary and concise language, and not necessarily in the language used in the statute, but in the terms sufficient to enable a person of common understanding to know what offense is being charged, as well as its qualifying and aggravating circumstances, and for the court to pronounce judgment. So, it is now required by the rules that the complaint or information, that the aggravating circumstances, whether qualifying or ordinary, otherwise the same cannot be properly appreciated by the court. So, the failure to allege the qualifying circumstances or the aggravating circumstances in the information will constitute denial of the accused of the right to be informed of the nature and cause of accusation against him. Thus, all aggravating circumstances must be alleged, otherwise they could not be used, even if proved during the trial, to aggravate the penalty in case of conviction. Okay, so let's classify the aggravating circumstances. So we have 4 classifications of aggravating circumstances. 1, we have generic, those that generally apply to all crimes, such as the following, to wit, in Article 14, paragraphs 1, 2, 3, 4, 5, 6, 9, 10, 14, 18, 19, and 20 of the Revised Penal Code. So, second is we have specific, those that apply to particular crimes such as cruelty, treachery, ignominy, etc. And qualifying aggravating circumstance, those that change the nature of the crime such as cruelty, treachery, evident premeditation. Let's say, for example, in treachery and evident premeditation, a homicide with the presence of treachery and evident premeditation could aggravate the crime or the felony to murder. Okay, if these are present or any of this is present. Now, the inherent, which is the last classification of aggravating circumstances, these are those necessarily present in crime but are not used in the definition thereof, such as sex is inherent in crimes against chastity. So, also abuse of public position in bribery and malversation of public funds, fraud in staffa, etc. So, these are inherent. So, take note that with the effectivity of Republic Act number 8284, the use of an unlicensed firearm in the commission of homicide or murder is no longer treated as a separate offense, but only as a special aggravating circumstance. So the same must be alleged in the information. Okay. I think that would be all for now. Let us proceed this discussion in the next part. Okay, so thank you very much, guys, for watching and for learning. So this is Wiser Pinoy TV, and thank you very much for watching. I hope that you will subscribe, like, and comment down whatever your opinions and your requests for this channel. Thank you, God bless, and enjoy learning.